Hi, I'm Jacqueline Rinksmeyer, Executive Director of the Greater Medina Chamber of Commerce.
And I'm Jared Fry, General Manager and Public Information Officer for the City of Medina and Medina TV.
One of the core values of the Greater Medina Chamber of Commerce is business advocacy. We've been proud to partner with Medina TV on this voter education series for well over 10 years now. We're grateful to our interviewer and General Manager of Medina TV, Jared Fry, and our producer, Matt Tomick.
We're grateful for all the candidates that took part in the Candidates Forum, but we also want to stress that the opinions of those candidates are not those necessarily of Medina TV or the Greater Medina Chamber of Commerce.
All candidates and contested races were invited to participate in this voter education program.
We want all voters to be informed to their best of the ability as they head to the ballot this November, so sit back and relax and enjoy our Candidates Forum.
We encourage you to make a plan to vote this November.
Joining me in studio now is the incumbent candidate for the Ohio Supreme Court, Justice Michael Donnelly. Thank you for joining us here today.
Thank you for having me.
Yeah, it's great to have you here, and we're honored by your presence.
Thank you.
Please take a few minutes and just for the people at home, because not often we get to talk with a Justice of the Supreme Court.
Sure.
Tell us a little bit about yourself.
Well, my name's Mike Donnelly, and I grew up on the west side of Cleveland. Went to St. Ignatius High School. Then I went to John Carroll University and Cleveland State Law School. And after law school, I joined the Cuyahoga County Prosecutor's Office as an assistant prosecutor for approximately 4.5 years. Then I went into civil litigation, first representing insurance companies in a variety of civil claims. Then I went to the other side. I went to another firm that represented plaintiffs, injured workers who had been injured by others' negligence. And so I was able to get a good view of the justice system from all sides, criminal and civil. And in 2004, I had my first opportunity to run for a trial court judge position in Cleveland, Ohio, where I sat for 14 years, where it was a job, frankly, I absolutely loved and never thought I would ever leave. I thought I would retire a trial judge. I enjoyed being part of the process of bringing resolution to conflict in people's lives. To me, that's what the courts are there for. They're there to resolve disputes and to protect people's rights enshrined in our Constitution, the Ohio Constitution and the federal Constitution. So I very much enjoyed that process. So that's in 2018, 2 seats became open on the Ohio Supreme Court. And I had always been part of a lot of reform efforts within the courts. I was an officer in the Ohio Common Pleas Judges Association. And some of these efforts were successful, some were not, but I thought to myself at that time, if I could gain a seat on our highest court, I could speak with more influence in order to try to improve the system. 9 of the years I was on the trial court, I was a mental health court judge. So 25% of my felony docket was made up of people who suffer from mental illness, schizophrenia, schizoaffective disorder, or were developmentally disabled. And I'm very proud of the fact that we were able to keep the vast majority of those folks out of the prison system, where they often go in, become abused, mistreated, come out worse than before, and keep the community safe at the same time. And so it taught me that we should always be questioning why we do things and how can we improve the system for the next generation.
Mm-hmm. Now, of course, most of the residents and voters don't get the opportunity to step foot in the Ohio Supreme Court, or they hope they don't have to, I guess. Kind of talk us through what the role of a justice is in the Supreme Court.
Sure, there's 7 justices, and our system is kind of a microcosm of what the federal court system is like. We have our trial courts, muni courts who handle misdemeanors and minor civil disputes. You have your courts of general division, where I sat, which handle felony criminal cases and major civil cases. And you have your specialized courts like the probate court, domestic relations, and the juvenile division. So when disputes are resolved in the trial courts, the checks that exist in the system allow the losing party, so to speak, to appeal their decision if they feel something took place incorrectly, either a ruling by the court or whatever. You're allowed to have that check and take your case to the Court of Appeals. We have 12 district court of appeals that cover the entire state of Ohio. And judges who are elected there sit in 3-judge panels to review those decisions that come out of our trial courts. Now, the highest court, the Supreme Court where I'm at right now, most of the time people who receive an adverse ruling at the appellate court, that's the end of the line, because in order to convince our court to take the case in, we're a court of discretion, and our discretion is we look at cases that we believe are of major, great public importance in order to settle dispute. We settle conflicts between the various appellate districts. But when we are looking at disputes, that's what we're looking at. Is this a matter that needs to be heard because it's going to affect a great many people, or it's just involves a subject matter that's so serious that I believe we should take it in? And that's going to be, whether it's a matter of great public importance, it's going to be in the eye of the beholder. So you need 4 votes to get a case into the Ohio Supreme Court. So every 2 weeks, we are constantly voting on maybe 50 to 80, we call them jurisdictional motions, petitioning and trying to convince at least 4 voters or 4 justices that this case is worthy to bring into the Supreme Court.
So it's interesting to parlay off that. So it's, once you get the 4 justices to see it, then of course you have to hear the case. Is it, what goes on then in the process? Is it, are you trying to win over the other 3 that maybe didn't agree with you, or to hear the matter?
For the very few cases that do get in, and it'll vary how many cases we take in from year to year. There's been a decrease in the last 2 years, but when Justice Stewart and I first were elected, we were pretty much taking in about 100 cases per year, but it's decreased. But what happens then the parties have a briefing schedule. Mm-hmm. They file briefs about their respective positions, and then we set the case for oral argument. And what we'll do is we'll ask questions of the attorneys, and we'll have our clerks prepare us for all the questions that we should be asking in order to determine which side is right. Should this case be reversed? Should this case be affirmed? Mm-hmm. And after that oral argument takes place, which is very important, we go up to a conference room and we go in order, and we start with seniority. The Chief Justice speaks first and states her position, whether she would vote to reverse, whether she would vote to affirm, and why. And why she's talking, no one can interrupt her. And it goes around the table according to seniority. The same rules apply. And then when the least senior justice is done, there's a actual deliberation. We talk to each other, and we respectfully, if we disagree with someone's position, we say why we feel the law means this, and this is how it applies to this set of facts. And then we vote on it, and we vote according to the least senior first, all the way up to the Chief Justice, and then you know initially where the case stands. Is it 4-3? Is it 5-2, 6-1, 7-0? Many of our cases are 7-0, as you would expect, because our obligation as justices is to follow the law. That's why I'm so upset that the Ohio legislature decided just recently to change what we've had for 100 years in general elections. Judges have never run with party affiliation, but they decided, even though it was opposed by the Ohio State Bar Association, even though it was opposed by the Ohio Judicial Conference, made up of all judges who are Republican personally or Democrat, they opposed it because in the judiciary, our allegiance is not to any political party. I have no, I'm a Democrat, but my allegiance is to follow the law. Mm-hmm. And so I've been on record for many years, long before I decided to run for Ohio Supreme Court, saying that we should get rid of partisan politics in the judiciary, because if you're doing your job right as a judge, you should be able to earn the support of both Republicans and Democrats. And I was very proud of the fact that in 2018, when I ran, I won 75 counties. So I would go to any group, no matter if conservatives in the rural areas, progressives in the major cities, and I found that they want basically the same thing from their justice system. They want transparency, they want fairness, and they want efficiency. They want and they want access, whether you have money or don't. That everybody deserves access to justice. So those are the types of policies, judicial policies, that I wanted to work on and improve upon by going to the Ohio Supreme Court. And fortunately, I won that opportunity in 2018.
Mm-hmm. And I think you said adding the parties, I think it was just recently here, like in 2021, that they did that. And that kind of leads me into, to dovetail off that, how do you, as a justice, handle that balance when you hear a case, whatever it may be, between whether it was a party affiliation, which I know you kind of just spoke on, your own personal opinion on items, and then also interpreting the letter of the law? That's right. How do you handle that balance?
Well, America has always been founded on the belief that we're going to differ. We're always going to have different opinions about policy. But once policy is enshrined in law, the rule is we all agree to follow the law. And if you don't like the law, you can work to change the law, and that's fine in our democracy. But we, as justices, as you just mentioned, everybody has their own biases. You might see a case and you wish that it came to this result for whatever party in the dispute, but the law is the law. And what I tell my clerks, I never want to be accused of result-oriented analysis. In the judiciary, you have to show your work. You have to write opinions to show why you believe the law should be interpreted in this way, and this is why the decision is rendered. You have to write an opinion, and that's why you have dissenting opinions if you believe that the majority is misinterpreting the law or leaving out facts that should be there that lead to a different determination. That's how we raise our voices. And there's once we decide a case initially at conference, we walk out, and there's a very important sign that hangs down at the Ohio Supreme Court, and it says, "Nothing we say in here is set in stone." And I think it's an important position that every judge should always remember, because you should always be open to the position that even though you're leaning towards one position, you may be convinced after you see your colleague's opinion that you were incorrect, and you may change your opinion, and that happens from time to time. You might be in the dissent, and you might write a dissent that's so persuasive that one of the other side flips, and the case flips to you, and all of a sudden you're writing the majority opinion. So I've had cases flip to me after I've written a dissent and circulated it, and I've had the opposite. So it's a very interesting dynamic of what justices you may align with. The public gets this perception, because we run under party label, that the 3 Democrats always vote one way and the 4 Republicans vote. That's not the case. Over 65% of our cases are 7-0. But because some high-profile cases get reported in the news, that perception is out there that we vote along party lines. But there's plenty of disputes that if you looked at the data that show that I will sometimes disagree with my Democratic-supported colleagues and join my Republican-supported colleagues. It's just how we see the law. Justices in good faith are going to look at statutes written in the English language and have different interpretations as to what this word means. Should this be interpreted broadly or narrowly? So, yeah, I believe if the public was aware of the data, they'd have a lot more confidence in our court system. And frankly, right now we're at a point in our history where the U.S. Supreme Court is at its lowest standing in terms of public confidence. And I think that's a danger in our democracy when people view the courts as just like another political, just like a mini legislature, like what we're trying to effectuate policy. I follow the law. If I believe the law renders an injustice on one group or another, I will say that in a concurring opinion. and urge the legislature to change it. But as judges, we're not policymakers. We are the ones that protect your rights that are contained in the Constitution, and help resolve disputes.
Yeah. We're speaking with Justice Michael Donnelly, the incumbent for the Ohio State Supreme Court Justice. And as you just mentioned there, interesting thing I think too, a lot of times in politics you want to hear people do a 7-0 vote or whatever their committee's made up of, be a unanimous vote.
Right.
But it's not necessarily needed. It's great that you guys, like you said, most times come to that, but it's not necessarily, you guys don't walk away upset if it's 4-3 or however the vote shifts. It's just the nature of looking at law, right?
No, we're a very collegial group. On every time we hear cases on Tuesday evening when we're down there, we all go to dinner together. Mm-hmm. And I think if people saw how we interact, and we could get back to a point in this country when people can disagree without being disagreeable, it would be a lot better thing. I think they'd have a lot of confidence in how we act, because it's not personal. Yeah. I get along with my Republican-supported colleagues very well. I have a lot of Republican friends. In fact, I have a lot of prominent Republicans in Northeast Ohio who have gone online and say, we're Republicans, but we're supporting Mike Donnelly because he believes in transparency, fairness, and improving the court system.
Yeah. Now, of course, all the candidates that we have in here, I always applaud them for taking the step and putting themselves in the political arena. It's a very difficult thing, especially in this day and age, to do so. What is your passion that drives you in politics and has you serve as a justice?
I would say transparency. I think it's the most important ingredient in instilling that public confidence, which is the lifeblood of the system. When I was a trial court judge, I began to look at how criminal cases are resolved a different way that I never questioned. A lot of mystery surrounds plea bargaining, which is most cases in our trial courts, 97% of cases don't go to trial. They are resolved through negotiated plea bargains. And there's a lot of mystery that surrounds plea bargaining, and there's good reason for that. A lot of these plea bargains get negotiated back off record in judges' chambers. And early on in my career as a trial court judge, I began to question why we do that, because, and I call this the greatest epiphany of my career, I came to the conclusion that no one should ever say anything in the back room that they wouldn't repeat verbatim on record with a court reporter taking it down. And so one day I said to my bailiff, hey, we're going to do things a little differently. We can have these same discussions, but we're going to have them outside on the record. That way the defendant, whose life may be profoundly affected by what's being discussed, is there. If there's a victim in the case, they can be there and hear how the case is being resolved and question what's taking place. I led an effort in 2016 to bring more transparency to the plea bargaining process, because I saw some disturbing things happening in other courtrooms. Cases were coming into the system alleging very serious forms of sexual assault, rape, and other forms of sexual assault. And then after a backroom discussion, people were being allowed to plead to charges that have nothing to do with rape. They're not lesser included offenses. They are just other offenses that people aren't questioning about it. They're actually offenses that the defendant did not commit in order to resolve the case. And I started collecting data on that, and I turned that over to the Cleveland Plain Dealer, and they did a front page story about it that your viewers can Google if they want to read that. And I led it all the way up to the Supreme Court, which I was not on at the time. I tried to change the rules that said if you try to plead a charge like rape out to some crime that has nothing to do with it, like aggravated assault, you can only accept that plea if the prosecutor can articulate facts on the record that, if true, would support what the person admitting to the crime. And if there are no facts to support that charge, I call these factually baseless pleas. The lawyers tend to call them legal fictions. Then you don't accept the plea. And that was rejected by the Ohio Supreme Court. And there's a Columbus Dispatch article that your viewers could Google that says Ohio Supreme Court rejects truth in sentencing rule. And it went kind of viral. It was reported all over the country. And to me, it's embarrassing. And it was one of the motivations that got me to run to the Supreme Court, because I think that the citizens and downstream users of our information that comes out of our justice system have a right to believe that those disputes are based in fact, based in truth. For instance, if you plead something out to something that the person didn't do, that's bad information you're putting in the system that downstream users want to be able to rely on. For instance, employers in Medina who are doing background checks. If they see someone had a minor misdemeanor assault in their record 10 years ago, they might not question what that was. But if they knew it started out as a rape charge, that might be concerning. So I'm trying to get these eliminated, and I haven't given up on that, even though the Supreme Court rejected it before my arrival.
So as a Supreme Court justice, what's something that you've been most proud of doing?
Well, one thing I led, as soon as I arrived there, I tried to come up with a system that eliminated the delay in civil litigation. I believe in maximizing efficiency in our civil dockets. That's good for business, because if businesses see that you have an efficient court system, they're going to be drawn to the state of Ohio, because businesses are inevitably going to be drawn into litigation, whether it has merit or it doesn't. And the sooner we resolve those cases, the more efficiently and with the least cost to businesses, the better. And so there's way too much delay. We don't have a unified court system in the state of Ohio. I believe we should start moving towards unifying our courts, because every judge should be, in my opinion, using a uniform case management order that provides every litigant with trial date certainty and ruling date certainty. I'm sure there's viewers out there that have been maybe drawn into frivolous litigation that they believe was completely meritless, and they went through and hired an attorney, and they filed a motion for summary judgment to get the judge to throw the case out because there's no merit to the claim. And the other side may have opposed it, but unfortunately, too many of our judges don't provide exact ruling dates that they can rely on. And as a consequence, if you don't have a ruling date set far enough in advance of the trial date, this is what happens. The client calls his attorney and says, hey, what happened to our motion for summary judgment? Well, we're waiting on the judge to rule on it. Well, can you call the judge, please, and ask them to rule? Well, you don't want to do that, because then we might not get the ruling that if we press them too hard. That's the dynamic that works. And all of a sudden, they're being told by their attorney, we have to start expending trial prep cases in order to get prepared for a trial that may not go forward, depending on that ruling. And that's very frustrating to the client, who may be a business out there, saying, why am I paying all these expenses? And they end up settling cases that they don't think should be settled, and they walk away with a bad taste about the justice system because of that inefficiency. I want to change that.
Yeah. So in the same breath, as you look to get reelected, upon reelection, what's something that you want to improve on with the Supreme Court?
Well, if you Google my name and you'll see that I'm the loudest advocate for collecting data about sentencing in the criminal justice system and creating a centralized database. Under our laws, our judges are told you are to treat similarly situated defendants with similar sentences, regardless of irrelevant factors like the color of the defendant's skin or their socioeconomic place in society. But in order to do that, you have to have what they have in the federal system, which your viewers may be surprised we don't have. We don't collect data on our sentences in order to help judges to carry out that mandate to keep sentences consistent. And as a result, sentences in Ohio are all over the board, from the extremely lenient for alleged violent offenses to extremely excessive for nonviolent offenses. And we have to get control of this. I've written a paper called "The Guardrails Are Off," that your viewers can Google my name, and it was published by Ohio State Law School. And I talk about, frankly, the problems that exist, that disparity, racial disparity and other forms of disparity are programmed into our sentencing laws right now. And the judges are powerless to do anything about it until we collect that data that will keep the system consistent, proportional, and fair.
Now, as a justice, I know a lot of times you're there and you're interpreting the laws as we've discussed, but are there, I know, like if you have a person in the legislature, they have passions or things they try to support or goals they work towards. Is there the equivalent of that in the Supreme Court? Are there things that you would like to see or things you guys like to do other than just interpreting the law?
Yeah, I take every opportunity I can to lecture at the law schools and teach the new generation that'll be coming in, to open their eyes of how the system really operates in ways that I think we can improve it. I'm very passionate about transparency in sentencing, transparency in plea bargaining, all of us want the same things from our justice system. We want to keep law and order. We want to protect the community against people who would have proclivities for hurting people. And, there's better ways than what we are presently doing in order to accomplish that at a much lower cost. And, and we have a disparity of resources throughout the state. I have friends on the judiciary, on the trial court, that are in the rural areas that say, I've had defendants before me that I know what's causing them to come into the court system is a drug problem that needs to be addressed. But we don't have the resources to give them the treatment that they need. So they ended up sending them to prison for 6 months, 7 months, and then they get out and they repeat the same thing again. And it should be no surprise, because the core of what's at the root of why they keep coming into the system for a great majority of people who enter the criminal justice system is not being addressed. And it's certainly not being addressed by a short sentence where you have this vicious cycle of them coming out and reoffending. So I think the collection of data and exploring more efficient ways to do it. There's always going to be a small fraction in 14 years of people who are a threat to public safety. And if they are not someone who can be rehabilitated, unfortunately, they have to be incarcerated. Mm-hmm. And I had to make those decisions on a daily basis as a trial court judge. But we should always be exploring, ways to keep sentences proportional, fair, and in line with that policy of rehabilitation, if possible, and making the punishment fit the crime.
Mm-hmm. Again, speaking with Justice Michael Donnelly, the incumbent for the Ohio Supreme Court, Justice for the Ohio Supreme Court, I should say. I want to make sure I thank you for taking time with me today. It's been a pleasure to speak with you, and I want to make sure I give you time on the microphone where you can talk directly to our voters at home. So without further ado, I'll give you the floor.
All right, thank you. Well, it's been an honor to be here. I really appreciate the invitation and talk about some of the issues. One thing I didn't mention that I'm very proud of, I was able to convince Chief Justice O'Connor to form a conviction integrity task force. I'm very concerned about the plight of people who are innocent that get convicted in our system. Innocent people have to often fight for years, sometimes decades, just to get a hearing to present new evidence or newly discovered evidence that they claim completely undermines the theory of guilt that was used to convict them. And sometimes they need to get celebrity involvement. Sometimes they need high press coverage of the case, and it shouldn't have to be that way. And I have fought to improve the post-conviction system so that hearings are held to make a determination if we have the correct, because the worst form of injustice I believe that can happen in our justice system is having someone innocent, something taken and have their freedom taken away, which we value the most as Americans. And we got to put a stop to it. And please visit my website, Donnelly for Ohio. You can read about all my reform efforts on there in detail, and all my articles that I've published are there. And I'm just grateful to the opportunity to come down to Medina. It's beautiful at this time of year, and meet with you, and hopefully earn your support for my reelection, because I do consider it a privilege to serve on the court. We serve at the privilege of the public. I do not mind running for reelection every 6 years, because I believe that's what our democracy is about. So hopefully your viewers have enjoyed it, and if they have any questions, they're free to contact me, and I'd love to talk to them about some of my initiatives.
Great. Again, that's Justice Michael Donnelly, the incumbent for the Ohio Supreme Court. I want to thank you for your time, and I want to wish you the best of luck this November.
Thank you very much.
Thank you.